2. Protection of First Amendment activities. In enacting FISA, Congress recognized that there may often be a narrow line between covert action and lawful activities undertaken by Americans in the exercise of their First Amendment rights. FISA thus includes a provision similar to the one found in the AGG-DOM and prohibits any U.S. person from being considered an agent of a foreign power solely on the basis of activities protected by the First Amendment. The House report explains that this provision is intended to reinforce the intent of the committee that lawful, page 34, political activity should never be the sole basis for a finding of probable cause to believe that a U.S. person is an agent of a foreign power. 3. Certification by an executive branch official. An application for electronic surveillance under FISA requires a certification by the director of the FBI or a similar official. The official must certify that a significant purpose of the electronic surveillance is to obtain foreign intelligence information. One definition of foreign intelligence found in the statute is information with respect to a foreign power or foreign territory that is necessary to the national defense for security of the United States or the conduct of the foreign affairs of the United States. The House report says that this category includes information necessary to national defense or security and the conduct of foreign affairs. It does not include information solely about the views or activities of private citizens concerning the foreign affairs or national defense of the United States. Another definition of foreign intelligence is information necessary to protect against clandestine intelligence activities by an intelligence service or network of a foreign power or by an agent of a foreign power. Certifying official must designate the type or types of foreign intelligence information sought and include an explanation of the basis for that certification. The official must also certify that the foreign intelligence sought cannot be obtained by normal investigative techniques, and the official must explain the basis for that certification. In other words, the official must explain why the government cannot obtain the information sought through other less intrusive techniques such as checking government records and publicly available information, interviewing the target of the surveillance, or using informants. This requirement, the House report says, is particularly important in those cases where U.S. citizens or resident aliens are the target of the surveillance. The certification requirement thus applies to the purpose of the surveillance and to the use of electronic surveillance as an investigative technique. By its terms, it does not apply to the accuracy or the factual information in the application. That is addressed by the sworn statement of the FBI agent or other federal official and by the executive branch requirements described below. 4. This is page 35. 4. Executive branch requirements. Over 20 years ago, the FBI adopted procedures designed to ensure the accuracy of the information contained in the FISA applications. These are often referred to as the Woods procedures. After their principal author, the recent OIG reviews of the page and other FISA applications raised concerns about compliance with the Woods procedures and the accuracy and completeness of the information in FISA applications. As a result, the Department has made numerous filings with the FISC, and the FISC has also directed that changes be made. For all applications, the FBI now requires that both an agent and a supervisor must affirm that the Office of Intelligence, OI, of NSD, which represents the government before the FISC, has been apprised of all information that might reasonably call into question the accuracy of the information and the applicable or otherwise raise doubts about the requested probable cause findings or the theory of the case. Before the government files an application for electronic surveillance of a federal elected official, a candidate for federal office, or a staffer of such a person, the Attorney General has directed that the FBI field office not involved in the investigation must review the case, file, and evaluate the proposed filing for accuracy and completeness. The Attorney General has also imposed other limitations on applications for electronic surveillance and politically sensitive matters. Defensive briefings. Before the government files an application with the FISC, the FBI director must consider conducting a defensive briefing of the target. Then, either the FBI must conduct a briefing, or if the director determines that such a briefing is not appropriate, the director must document that determination in writing. This is in addition to the general requirement described above for the FBI to establish procedures for defensive briefings. Duration of surveillance. The maximum duration the government may seek from a FISC or surveillance is 60 days. This is shorter than the statutorily permitted 90-day maximum for surveillance of a U.S. person. In addition, every 30 days, the government, page 36, must report to the FISC on the results of the approved surveillance and the continued need for such authority. D. Statutes used to evaluate possible criminal conduct. This section begins with a brief description of the burden of proof that the government faces in every criminal case. It then describes the principal statuses that we consider to evaluate possible criminal conduct and exactly what must be proven beyond a reasonable doubt in order for a jury to convict. 1. Standard of proof beyond a reasonable doubt. The government has the burden of proving that a defendant committed to any criminal offense beyond a reasonable doubt. A standard jury instruction on reasonable doubt is, the government has the burden of proof, name of defendant, guilty beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or in some cases, that its truth is highly probable. In criminal cases such as this one, the government's proof must be more powerful than that. It must be beyond a reasonable doubt. Reasonable doubt, as the name implies, is a doubt based on reason, a doubt for which you have a reason based on the evidence or lack of evidence in the case. If after careful, honest, and impartial consideration of all the evidence, you cannot say that you are firmly convinced of the defendant's guilt, then you have a reasonable doubt. Reasonable doubt is the kind of doubt that would cause a reasonable person, after careful and thoughtful reflection, to hesitate to act in the graver or more important matters in life. However, it is not an imaginary doubt, nor a doubt based on speculation or guesswork. It is a doubt based on reason. The government is not required to prove guilt beyond all doubt or to a mathematical or scientific certainty. Its burden is to prove guilt beyond a reasonable doubt. False statements. That's number 2. The principal federal statute criminalizing false statements to government investigators is 18 U.S.C. 1001. That's Section 1001. As relevant here, subsection 1001A2 makes it a crime in any matter within a jurisdiction of the executive branch of government knowingly and willfully to make any materially false, fictitious, or fraudulent statement or representation. The government must prove 5 elements beyond a reasonable doubt to obtain a conviction under this provision. First, the defendant made a statement or representation. Second, the statement or representation was false, fictitious, or fraudulent. Third, this statement or representation was material. Fourth, the false, fictitious, or fraudulent statement was made knowingly and willfully. And fifth, the statement or representation was made in a matter within the jurisdiction of the executive branch of the government. The Mueller Report contains, we're on page 37. The Mueller Report contains additional discussion of these requirements. An FBI investigation is a matter within the executive branch's jurisdiction, United States v. Rogers, blah, blah, blah. The statute also applies to a subset of legislative branch actions, administrative matters, and investigative reviews conducted by a congressional committee or subcommittee. Whether the statement was made to law enforcement or congressional investigators, the government must prove beyond a reasonable doubt the same basic non-jurisdictional elements. The statement was false, fictitious, or fraudulent. The defendant knew both that it was false and that it was unlawful to make a false statement, and the false statement was material. Also, Ninth Circuit pattern instruction, blah, blah, blah. This is a bunch of legalese stuff. 3, perjury. 18 U.S.C. Section 621 provides that whoever, having taken an oath before a competent tribunal, officer, or person in any case in which a law of the United States authorizes an oath to be administered, that he will testify, declare, depose, or certify truly, or that any written testimony, declaration, deposition, or certificate by him describes is true, willfully, and contrary to such oath, states or subscribes any material matter which he does not believe to be true, or in any this is page 38, in any declaration, certificate, verification, or statement under penalty of perjury is permitted under Section 1746 of Title 28 United States Code, willfully subscribes as true any material matter which he does not believe to be true, is guilty of perjury. Whoever under oath or in any declaration, certificate, verification, or statement under penalty of perjury is permitted under Section 17406 of Title 28 United States Code in any proceedings before or ancillary to any court or grand jury of the United States knowingly makes any false material declaration or makes or uses any other information, including any book, paper, document, record, recording, or other material, knowingly the same to contain any false material declaration, shall be fined under this title or imprisoned not more than 5 years or both. The Department's Criminal Resources Manual states that Sections 1621 and 1623 share 4 common elements. The government must prove each element beyond a reasonable doubt. The manual summarized these elements as follows. The first element of perjury offense is that the defendant must be under oath during his testimony, declaration, or certification, unless the perjurious statement is an unsworn declaration permitted by 28 U.S.C. Section 1746. The second essential element is that the defendant must have made a false statement. The third element is proof of specific intent, that is, that the defendant made the false statement with knowledge of its falsity, rather than as a result of confusion, mistake, or faulty memory. The false statement must be material to the proceedings. In addition to the text quoted above, the manual explains each of the requirements in more detail, as well as the differences among the statutory provisions. This is number 4, falsification of records. 18 U.S.C. Section 1519 imposes criminal liability on any person who knowingly falsifies or I'm backing up a little bit, I was interrupted. 4. Falsification of records. 18 U.S.C. Section 1519 imposes criminal liability on any person who knowingly falsifies or makes a false entry in any record, document, or tangible object with the intent to impede, obstruct, or influence the investigation or improper administration of any matter within the jurisdiction of any department or, page 39, agency of the United States, or in relation to or contemplation of any such matter. The government must prove 3 elements beyond a reasonable doubt to obtain a conviction under Section 1519. First, the defendant knowingly falsified a document. Second, the defendant did so with the intent to impede, obstruct, or influence an investigation or the proper administration of a matter. And third, the investigation or matter was within the jurisdiction of the Department, the FBI, or another federal department of agency. 5. Obstruction of justice. There are several statutes that cover conduct intended to obstruct or impede government investigations. 18 U.S.C. Section 1512 C.2 is an omnibus obstruction of justice provision that covers a range of obstructive acts directed at pending or contemplated official proceedings. 18 U.S.C. Section 1503 and 1505 also offer broad protection against obstructive acts directed at pending grand jury, judicial, administrative, and congressional proceedings, and they are supplemented by a provision in Section 1512B aimed specifically at conduct intended to prevent or hinder the communication to law enforcement or information related to a federal crime. The Mueller report describes these requirements and noted that 3 basic elements are common to the obstruction statutes pertinent to the office's charging decisions: an obstruction act, some form of nexus between the obstructive act and an official proceeding, and criminal or corrupt, like as if corrupt intent. 6. Violation of civil rights. 18 U.S.C. Section 242 makes it a crime for anyone acting under color of law willfully to deprive any person of a right secured by the Constitution or laws of the United States. The government must prove 3 elements beyond a reasonable doubt to obtain a conviction under Section 242. First, the defendant deprived the person of an identified right, such as the right of due process of law secured by the Constitution or laws of the United States. Second, the defendant acted willfully, that is, the defendant committed such act or acts with a bad purpose to disobey or disregard the law, specifically intending to deprive the person of that right. To find that the defendant was acting willfully, it is not necessary for the government to prove that the defendant knew the specific constitutional provision or federal law that his or her conduct violated, but the defendant must have a specific intent to deprive the person of a right protected by the Constitution or federal law. Page 40. Third, the defendant acted under color of law. Acting under color of law means acts done under any state law, county, or city ordinance or other governmental regulation, and acts during or done according to a custom of some governmental agency. It means that the defendant acted in his or her official capacity or else claimed to do so, but abused or misused his or her power by going beyond the bounds of lawful authority. conspiracy to violate civil rights. Section USC 241 makes it a crime to conspire to deprive a person of his or her civil rights. The government must prove three elements beyond a reasonable doubt to obtain a conviction under Section 241. First, the defendant entered into a conspiracy to injure, oppress, threaten, or intimidate a named victim. Second, a defendant intended to interfere with the named victim's exercise or enjoyment of a right that is secured or protected by the Constitution or laws of the United States. And third, the named victim was present in any state, district, or territory of the United States. 8. General Conspiracy Statute. A conspiracy under 18 U.S.C. Section 371 requires the government to prove four elements beyond a reasonable doubt. First, two or more persons in some way agree to try to accomplish a shared and unlawful plan. Second, the defendant knew the unlawful purpose of the plan and willfully joined in it. Third, during the conspiracy, one of the conspirators knowingly engaged in at least one overt act as described in the indictment. And fourth, the overt act was committed at or about the time alleged and with the purpose of carrying out or accomplishing some object of the conspiracy. In addition to criminalizing an agreement whose object is to violate federal criminal law, Section 371 also criminalizes a conspiracy to defraud the United States or any agency thereof for any manner or for any purpose. This may also include interfering with the performance of official duties by government officials. 9. Campaign contributions. 52 U.S.C. Section 30116A1A provides that no person shall make contributions to any candidate and his authorized political committees with respect to any election for federal office which, in the aggregate, exceeds $2,000. The term person includes an individual, partnership, committee, association, corporation, labor organization, or any other organization or group of persons. Contributions are defined as any gift or deposit of anything of value made by any person for the purpose of influencing any election for federal office. Contributions do not include the value of services provided without compensation by any individual who volunteers on behalf of a candidate or political committee. Section 30116C provides for adjustments for inflation, stating that limitations for contributions by persons to federal candidates are adjusted every 2 years. The limitation for an individual donor to a candidate committee for the 2015-2016 election cycle was $2,700. Violations of Section 30116 by a person qualify as a crime if the violation involved at least the amount specified in a calendar year, and 2, the violation was committed knowingly and willfully. 10. Campaign contributions by foreign nationals. 52 U.S.C. Section 30121A1A makes it a crime for a foreign national, directly or indirectly, to make a contribution or donation of money or other thing of value, or to make an express or implied promise to make a contribution or donation in connection with a federal election. Subsection A2 makes it a crime for any person to solicit, accept, or receive such a contribution or donation. 11. Fraud against the United States. 18 U.S.C. Section 1031A imposes criminal liability on whoever knowingly executes or attempts to execute any scheme or artifice with the intent to defraud the United States or to obtain money or property by means or false or fraudulent pretenses, representations, or promises. Page 42. In any grant, contract, or other form of federal assistance, if the value of such grant, contract, or other form of federal assistance is $1 million or more, the government must prove three elements beyond a reasonable doubt to obtain a conviction under Section 1031A. First, the defendant knowingly used or tried to use a scheme with the intent to defraud the United States or to get money or property by using materially false or fraudulent pretenses, representations, or promises. Second, the scheme took place as part of acquiring property, services, or money as a contractor within the United States or as a subcontractor or a supplier and on a contract with the United States. And third, the value of the contract or subcontract was $1 million or more. 12. Money laundering. 18 U.S.C. Section 1956A1A imposes criminal liability on whoever knowing that the property involved in a financial transaction represents the proceeds proceeds of some form of unlawful activity, conducts or attempts to conduct such financial transactions which in fact involve the proceeds of specified unlawful activity with the intent to promote the carrying on of specified unlawful activity or with intent to engage in conduct constituting a violation of Section 7201 or 7206 of the Internal Revenue Code of 1986. To obtain a conviction under Section 1956A1A, the government must prove the following three elements beyond a reasonable doubt. First, the defendant conducted or attempted to conduct a financial transaction involving property constituting the proceeds of a specified unlawful activity. Second, the defendant knew that the property involved in a financial transaction was the proceeds of some form of unlawful activity. And third, the defendant acted either with the intent to promote the carrying on of specified unlawful activity or with the intent to engage in conduct violating certain provisions of the Internal Revenue Code. 18 U.S.C. Section 1957 imposes criminal liability on whoever knowingly engages or attempts to engage in a monetary transaction in criminally derived property of a value greater than $10,000 and is derived from, page 43, specified unlawful activity and does so either in the United States or in the special maritime and territorial jurisdictions of the United States or outside the United States and such special jurisdiction, but the defendant is a United States person. To obtain a conviction under Section 1957, the government must prove the following five elements beyond a reasonable doubt. First, the defendant engaged or attempted to engage in a monetary transaction in or affecting interstate commerce. Second, the monetary transaction involved criminally derived property of a value greater than $10,000. Third, the property was derived from specified unlawful activity. Fourth, the defendant acted knowingly, that is, with the knowledge that the transaction involved proceeds of a criminal offense. And fifth, the transaction took place in the United States or the defendant is a U.S. person. Finally, 18 U.S.C. Section 1956H imposes criminal liability on any person who conspires to commit any offense defined in Section 1956 or 1957. To obtain a conviction under Section 1956H, the government must prove the following three elements beyond a reasonable doubt. First, two or more persons reached an agreement to commit one of the specified offenses. Second, the defendant voluntarily or intentionally joined in the agreement or understanding either at the time it was first reached or at some latter time while it was still in effect. And third, at the time the defendant joined in the agreement or understanding, he or she knew the purpose of the agreement or understanding. 13. Disclosure of national defense information. 18 U.S.C. Section 793D imposes criminal liability on whoever lawfully having possession of, access to, control over, or being entrusted with any document, writing, code book, signal book, sketch, photograph, photographic negative, blueprint, plan, map, model, instrument, appliance, or note relating to the national defense or information relating to the national defense, which information the possessor has reason to believe could be used to the injury of the United States or to the advantage of any foreign nation, willfully communicates, delivers, transmits, or causes to be communicated, delivered, or transmitted, or attempts to communicate, deliver, transmit, or cause to be communicated, delivered to, transmitted the same to any person not entitled to, page 44, received it, or willfully retains the same and fails to deliver it on demand to the officer or employee of the United States entitled to receive it. Modern federal jury instructions summarize the elements that the government must prove beyond a reasonable doubt to obtain a conviction under Section 793D. First, the defendant had lawful possession of or access to or control over a described document. Second, that the document was related to the national defense. Third, that the defendant had reason to believe that the document could be used to the injury of the United States or to the advantage of, name a foreign country. Fourth, that on any date the defendant willfully communicated or delivered or transmitted to or caused to be communicated, delivered, or transmitted, or attempted to communicate, deliver, or transmit the document to the person who is not entitled to receive it. 4. Background facts and prosecution decisions. This section begins by providing factual information about the FBI's New York Field Office, NYFO, investigation of Carter Page in the spring of 2016, subsection A1, the text messages between certain FBI officials that on their face show a predisposition to investigate Trump. subsection A2, and the predication, opening, and conduct of Crossfire Hurricane investigation, subsection A3 through A5. This part concludes with a comparison of some of the FBI's investigative decisions related to Clinton with some of those related to Trump, subsection A6. The remaining parts of this section each include a factual background and then describe the prosecutive decision the office made. The first addresses an investigative referral of a possible Clinton campaign plan, subsection B. The next is an extensive discussion of the FISA application targeting page, subsection C. The last part of this section covers conduct by private sector actors in connection with Crossfire Hurricane and related subjects, subsection D. In describing these matters, this section does not endeavor to repeat or restate all the information that the office and others have covered and made public. Instead, it aims to add to that body of information, including additional relevant facts, and explain the prosecutive decisions we made. The appointment order authorized the special counsel to prosecute federal crimes arising from his investigation of the matters assigned to him. What is stated in the Mueller report is equally true for our investigation. In deciding whether to exercise this prosecutorial authority, the office has been guided by the principles of federal prosecution set forth in the Justice Manual. In particular, the office has evaluated whether the conduct of the page 45 individuals considered for prosecution constituted a federal offense and whether admissible evidence would probably be sufficient to obtain and sustain a conviction for such an offense. Where the answer to these questions was yes, the office further considered whether the prosecution would serve a substantial federal interest, the individuals were subject to effective prosecution in another jurisdiction, and there exists an adequate non-criminal alternative to prosecution. These considerations, as explained below, led the office to charge 3 individuals with making false statements. The office considered whether other individuals, including individuals in the government, made false statements to the FBI, the OIG, or congressional committees, or whether during the course of the office's investigation or other individuals interviewed either omitted material information or provided false information. Again, what is stated in the Mueller report is also true for our investigation. Applying the principles of federal prosecution, the office did not seek criminal charges against any individuals other than those listed above. In some instances, that decision was due to evidentiary hurdles to proving falsity. In others, the office determined that the witness ultimately provided truthful information and that considerations of culpability, deterrence, and resource preservation weighed against prosecution. The office determined that other matters it investigated either did not involve the commission of a federal crime or that our evidence was not sufficient to obtain and sustain a criminal conviction. In addition to its prosecution and declination decisions, the office made the following referrals to other entities. A referral on June 30, 2020 to the FBI's Washington Field Office, WFO, regarding a matter related to an existing counterintelligence investigation. A referral in December 2020 of OI of information relevant to the accuracy of information contained in 4 non-page FISA applications. Referrals of 2 matters on December 14, 2022 to the Inspector General of the Department of Defense with a copy of the General Counsel and the Defense Intelligence Agency. One matter involved the execution of a contract between DARPA and the Georgia Institute of Technology, and a separate matter involved the irregular conduct in 2016 of 2 former employees of the Department of Defense. A referral to the FBI's OGC and Inspection Division of an FBI agent for failing to document properly the known history of Igor Danchenko upon his opening as an FBI CHS. Page 46. A referral to the FBI's OGC and Inspection Division of the same FBI agent for questionable instructions given to Danchenko regarding the taxability of cash payments made to him by the FBI. In addition to the referrals described above, the office also provided information to the FBI's Inspection Division regarding certain activities by current and former FBI employees.